Okay, are we
The
ready?
Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you. Welcome to everyone. As you can see, we had a few little glitches to start out, but I think we're back on track. We will proceed as though we're in court. Some call this virtual. This is not virtual. This is actually real court. So you're in the right place. Your judges today, Judge Harris and Judge Quattlebaum and myself. This case we're about to hear, I hope, is Kirk versus Commissioner of Social Security. Is that correct? Good. Then we will proceed by hearing from the appellant.
Good afternoon, and may it please the court. Thomas Pullum for the Commissioner of Social Security. Because this case involves a challenge to the administrative procedures used by the Social Security Administration in its redeterminations, I think it makes sense to begin with a summary of the administrative process that was provided here. First, SSA's Appeals Council internally reviewed each application to determine whether the award of benefits could be supported by the remaining untainted evidence in the case file after disregarding evidence identified by the Inspector General.
Oh, Counsel, can I actually ask you a question right at the very beginning of the process?
Yes.
Yes. Even before that happened, right, someone did like a search of thousands and thousands of files to see who was connected to this con fraud. Is that right?
The Inspector General carried out an investigation of the fraud. That's
okay.
Correct.
All right. And what if an error had happened at that point? Like, what if somebody sent put in the con fraud pile a case that didn't belong there, like maybe Huffnagel was the treating physician or something, but the report came in having nothing to do with con. How would somebody challenge that? Just like a clerical error.
So if the case didn't involve evidence submitted by con, then it wouldn't have been disregarded by the ALJ.
Right.
The ALJ specifically only disregarded evidence that was signed by one of these physicians and submitted by con himself.
Right, but and I'm saying, just imagine hypothetically some kind of a clerical error, like someone said it was submitted by con, but it actually wasn't. And so now the ALJ is disregarding it. Is there anything the applicant can do to say, I've never heard of this con person, he wasn't my lawyer, Huffnagel was my personal physician, I don't know why I'm here? Or is the government's position, there's nothing you can do, but it doesn't really matter because putting in the con report wouldn't make much of a difference?
Well, I would like to get to the issue of whether this would make any difference, but I believe that in that circumstance where con was not the lawyer, I mean the applicant could have brought that to the ALJ's
you could raise it before the ALJ.
Because the ALJ could only not review the exclusion of evidence that had been identified by the Inspector General, and the Inspector General's referral specifically referred to reports that were signed by the physicians and
I don't want to hold you up on this. I understand why it shouldn't play out that way. I'm just asking you to imagine somebody made a mistake. A file got put in the wrong pile. It got put in the con pile, although it should not have. And nobody did anything on purpose, but there, it's thousands and thousands of files. A mistake got made. That's all. So how does that get fixed?
Well, I'm not sure it would if it somehow kind of made it within the scope of the referral. But as Judge Rogers explained, the nature of the investigation here provides kind of assurance as to the reliability of what the Inspector General did, which was kind of the investigation into the whole fraud was carried out, and then the Inspector General identified forms that matched the template forms. And that was how cases were identified here. And the evidence that was excluded here, I think it's important to look at what that was, because this may get to Your Honor's question about whether it would make a difference, was this RFC form that purported to identify the claimant's kind of capacity to work, and a short narrative report that, according to the RFC form, was provided explanation for the conclusions listed on the form. This was the report provided by a doctor hired by the attorney who met with the beneficiary at most once. Under no circumstances could this be entitled to controlling weight, as Judge Daugherty gave it. And so that's why these forms kind of seem to take on an outsized importance in these adjudications. No ALJ properly following SSA's regulations, which Daugherty did not, would give these forms that kind of determinative weight. And so the exclusion of the form is, yes.
Counsel, if I could ask a question that relates to timing. It appears from the record that the first, or at least one of the earliest times this kind of came to light was in 2006. And then the investigation, Inspector General's activities doesn't begin until sometime 2010, perhaps around the time of the Wall Street Journal article, or at least generally. And at least there's allegations that delay made it more difficult for some claimants to attempt to provide other evidence besides the tainted form, as you call it. What role does that delay play in our legal analysis? Does it play any? If so, where does it fit from a structural legal analysis?
So I don't think it plays any role here. There's no claim in this case, as there was in Hicks, that the delay somehow deprived the Social Security Administration of moving forward with the redeterminations. The Sixth Circuit rejected that claim. It's not present here. And I don't think it affects the due process analysis at all, because we're looking at whether there was a risk of error in the termination of benefits here. And I don't think there's any real reason to believe that the delay contributed to a risk of error. To be sure, the plaintiffs have made some comments about how the passage of time makes it more difficult for them to obtain medical records, but all of their medical records should already be in the case file as a result of their applications and the SSA's normal evidence development practices. Both of the plaintiffs here stated during their administrative processes that their records were complete on redetermination, and they haven't identified any records that were actually missing from their files. Had they done so, they could have brought it up at the redetermination and asked the ALJ for assistance in further developing the case file, but that wasn't done.
If I could follow up on that, your answer referred to these plaintiffs a couple times, perhaps in a way that's different than the Hicks plaintiffs, for example, and that brings up a question which I want to ask your colleague as well. Are we supposed to look at it that way on an individual basis, or are we supposed to look at this categorically from a due process standpoint?
I think we look at it kind of generally how the process plays out in the mine run of cases, kind of without being distracted too much by a severe hypothetical that hasn't occurred or is very unlikely to occur. These plaintiffs, what happened to them was, by all accounts, I believe, pretty standard for how the process was supposed to work. These redeterminations.
What's your authority, counsel? What's your authority for that proposition? That we look at it generally as opposed to a maybe one-off unusual situation? I
don't have a case at hand, I'm afraid, but my recollection from reading due process cases is that you look at how the procedures kind of are did work and are generally meant to work. And the balance could tip.
I'm sorry, maybe you're just about to get to this. The standard itself asks us to look at the risk of error, right? So that seems different to me than from just asking, how does it mostly play out?
Well, I think that's
supposed to ask, what is the risk that it won't play out that way?
But I think that's part of a kind of realistic assessment of risk of error. I mean, if there's something that is, kind of theoretically possible, but is never actually going to, happen in the real world, there's no indication that it's likely to happen, that's a very, very small risk of error and would kind of factor into the Matthews analysis that way. If there were a serious risk of error, then the balance could tip differently. But I don't think we have a serious risk of error in these cases.
And that, just so I understand.
No, go ahead, Judge Harris. No, you go.
No. Well, can you just the reason there's no serious risk of error here, because just as a matter of common sense, the idea that you would have to reconstruct your medical history from many years ago just seems like it would be quite burdensome and sometimes hard to do. And particularly hard to do maybe for people who were caught up in this Khan thing because he wasn't papering the files properly. He was just relying on the fraudulent residual function, RFC, RCFs. And then even when the government got the reports, right, they all got lost or something. I can't quite remember what happened with all the reports that were seized or the medical records that were seized. So the reason against all of that, we have that if everything works the way it's supposed to work, the original ALJ will have made sure, who was the original? How will the file have been papered if Khan didn't file it and it's part of the fraud? So the ALJ himself is in on it. Who's making sure everything's in that file?
So before it even gets to an ALJ, it goes through an administrative process through what are called the DDS offices. These are the state agencies that work kind of process the claims for the Social Security Administration. So when someone applies for benefits, part of this process is the agency asks the person to identify all of their treatment providers. There's a form that says, list everyone who might have medical records for you. And the person is also invited to submit medical records. So what the agency does is they take all of the records that are submitted. They also reach out to those providers to get records from them. That's what is referred to as the development process. When I use that word, that's when SSA goes out and gets these records. There's a regulation that requires SSA, before it denies benefits, to construct a complete medical history of the past 12 months before the application time. So all of that evidence is in the case file from the application initial decision. Then there's a redetermination that happens before an ALJ gets involved. The process happens again. Ask who are your treatment providers. SSA reaches out to them to get records, invites the applicant to provide records that he or she has. So all of that is already in the case file. Khan did not submit this evidence until it got to the ALJ hearing and where Judge Daugherty was involved. That was the fraud, was to submit this evidence that Judge Daugherty solicited. The way it's described in the Senate report and the criminal documents is Judge Daugherty would call Khan's office, say, I need physical or mental evidence. And depending on which one it was, Khan would arrange with one of his associated physicians to sign the form, in some cases, write the report, and that would be submitted to Daugherty.
Speak to this. Do we need to apply this Matthews three-factor balancing test to reach the result here?
Yes, we do. As this court and the Supreme Court have said many times, the Matthews balancing test is the means by which a court determines whether a meaningful hearing has been provided in a meaningful time. There's no dispute here that the plaintiffs received hearings on the question of their entitlement to benefits. What they're saying is that
did the Sixth Circuit do so in the Hicks case?
So the Sixth Circuit did say that this case was governed by kind of some other type of due process, what the plaintiffs refer to as a kind of minimum due process. Judge Rogers explained why that was inconsistent with 40 plus years of Supreme Court precedent, and it finds no anchor in the Constitution itself, which just guarantees a right to due process. There's no kind of minimum due process that's assessed one way and other due process that's assessed another way. The guarantee, as Matthews explains, is the right to a hearing in a meaningful manner in a meaningful time. And the way we assess whether a hearing was meaningful under the circumstances is the application of the Matthews test. So if we're at a breaking point, I'm happy to reserve time for my rebuttal.
All right, we can do that. We'll hear from your opponent.
Thank you.
Ms. Stewart, can you hear us?
Apologies, I was trying to unmute. Good afternoon, Your Honors, and may it please the court. My name is Alexandra Stewart, and I represent plaintiffs Gary Kirk and Larry Taylor.
What do you say is the issue in this case? We've been going around a lot of legal arguments, but what's the issue here? Is it a concern about due process and not being able to address a matter that's been sort of handled in a per se manner? What is the issue in this case?
Yes, Your Honor. The issue is fundamentally opportunity to be heard. So that right is guaranteed under the Due Process Clause. And as the Seventh Circuit held in Jackson v. Saul, it's also a fundamental part of agency proceedings, the ability.
So you got two circuits, you got the Seventh and the Sixth Circuit, somewhat different rationale that have gone in your favor on it. Do we need to apply that Matthews three-factor balancing test here?
No, Your Honor. And as Judge Thapar said in the district court opinion in Hicks, when the naked eye can see that the process falls short of the mark, courts need no measuring tape. So that's our position on Matthews. Since plaintiffs have not.
Ms. Stewart, if I could follow up on that, does Matthews say that there's some floor proceeding or some other proceeding that you apply, or does any other case from the Supreme Court since Matthews say what you just said? I mean, I know you can look at, I don't mean to, I want to make sure my question's clear. I know you can make an argument for other cases. I've read that, and I'm not trying to say those aren't correct. But isn't it true that the Supreme Court has never said what you just said?
The Supreme Court has not explicitly said that you don't need to reach the three factors if it's obviously deficient in terms of opportunity to be heard. So but that's not necessary to our position. We're just saying that there are certain things that can't be balanced away. And so whether you plug them into the Matthews test or you just examine them on their own, they can't be balanced away under any standard. So no matter what standard you apply, the opportunity to be heard is a fundamental aspect of a meaningful hearing. And the plaintiffs didn't have that in this case.
Well, but isn't the private interest that you assert to be violated the discontinuance of the disability benefits?
Yes, Your Honor.
And there you had multiple opportunities to be heard in connection at the proceeding where that determination was made. It seems like your argument is, despite that, because there was not an opportunity to be heard at the exclusion of the reports process that that your rights have been violated. But does it matter that that exclusion was not the final decision into whether your benefits were terminated or not?
No, Your Honor, it doesn't matter that it wasn't the ultimate issue. Due process includes the right to be heard on important factual determinations that lead up to the ultimate issue. So although we did have the right to be heard on the ultimate question of whether the claimants were disabled at the relevant period, it was important. The determination that their best evidence was fraudulent was important. And so an important component of due process was the right to be heard on that determination.
Can I ask you, counsel, just on this point about how important it was, maybe to respond to the government just in a couple of sentences? I mean, as I understand it, their basic argument is it wasn't important. Like everything you needed was already in the file. And that's not just coincidence. That's as a matter of the way the agency does its business. It really doesn't matter, these reports from the fraudulent doctors. And even if they had come in, they'd come in with these huge credibility question marks, so it wouldn't have made any difference. So why is it practically important?
It's important for several reasons, Your Honor. First, it's true that the agency is supposed to gather medical evidence from the 12 months prior that is available from a claimant's physicians, treating physicians, or hospital visits. But most of that evidence is not going to be medical opinion evidence. So it won't be opining on how the person's physical conditions affect the person's functional capacity. And so in this case, the only opinion evidence that the plaintiffs solicited was from these doctors. And in Kirk's case, there was opinion evidence from his treating physician's assistant that wasn't credited. So it was important in that these were the only people on these claimants' side opining that their physical conditions, which were in the record, actually had effects on their ability to perform work. And so it was important in the initial stage for them to have that opinion evidence. And it's even more important at the redetermination stage, given the length of time between the initial determination and the redetermination. So Mr. Taylor, for example, submitted evidence of his degenerative disc disease, but it was deemed to be outside of the relevant time period. So there's just not a good way to recreate evidence about someone's limitations from years earlier. This is,
returning to Judge Qualibon's concern, and that is, you look at the specific reports here, and that's what your challenge is, the fact that you're not able to use those reports, not that you can't ultimately bring in some more evidence and more information on it. And so that is the big challenge you got here. If you look at in terms of what seems to be established in criminal violations, which are not part of the record, but at least known, that this procedure definitely fit within what one would call fraud. If all of these things happen, this lawyer sort of fabricated a procedure that for all of these different clients. So fraud, let's assume it just exists. What happens with your clients if we agree with you? I mean, what happened in the Hicks case? I'm really confused about that, because it looks to me all you're doing is asking for a chance to rebut whatever. What if that little procedure is allowed to get up and rebut? And where does that go? I'm not following that at all. It looks like to me it goes nowhere, because everything that's pointing there, unless you can say, no, he didn't do that in my particular case. Is that all you're asking for, that you want to be able to prove in your particular case this didn't happen? You can't categorically put them all together that happened in every case? Or would evidence from a criminal trial that in your case that it did happen be sufficient?
Your Honor, we are only asking to be able to say that it did not happen in our case.
So what happens when you go back? What happened in Hicks to those plaintiffs there? When they send it back, what happened?
The agency hasn't conducted those redetermination hearings yet. And so we don't have an application of what happened.
What's the procedure? What's the procedure that the trial court used or is to be used in that case? I mean, you said hearing, and it seems to be rather limited in terms of what you are seeking here. So what type of hearing are you talking about?
Well, it doesn't have to be a separate hearing, Your Honor. It can just be part of the ordinary redetermination hearing. But the procedure that the agency has laid out includes an OIG affidavit saying that this is the basis that we used to sweep up this particular case into the broader pattern or scheme. And then the plaintiff is able to submit rebuttal evidence and say, these are the tests that they conducted. This is my testimony about what happened in my case and the examinations that they performed. And so they can say that it didn't happen in their case.
Basically, the plaintiff was seeking to say that it wasn't fraud in their case, you're saying?
That, yes, that the doctor's evidence, that their observations, particularly the report accompanying the RFC forms, that those observations were genuine and that they were not fraudulent. Yes. And
Can I clarify? Because this is, I just want to make sure I understood what you said. So you're not asking, I had this question too, that there be an OIG witness who's going to get up there and be cross-examined. You're not asking for that. You're asking for more what the court's talking about in Jackson. Just a chance to make your argument by motion. And in the vanishingly small set of cases where there's a fact dispute, you might have to have actual factual development. But mostly, either you won't be able to make your case or you will.
That's exactly right, Your Honor. And I will say at the outset, the agency has never provided the criteria that it used in identifying cases for the OIG referral. There's never been an assertion that every single case handled by Doherty, or every single case handled by the doctors, or every case with all three of those criteria fit within the OIG referral. And certainly that was not part of the OIG referral. So we don't know what criteria. Yeah, yes, Your Honor.
You can finish your answer. I'm sorry. Go ahead. I didn't mean to cut you off.
I was just going to say we don't know what criteria they used. We don't know what subset of those cases were identified as being part of the fraud and which ones they decided did not have any reason to believe were fraudulent. And so we would like an opportunity to show that our cases fit within those that are not fraudulent.
Let me ask a question, please, that I asked your colleague about whether we look at the peculiar situation of your clients here or whether we look at this situation categorically. I'm reading from Matthews, and it says that procedural due process rules are shaped by the risk of error inherent in the truth-finding process as applied to the generality of cases, not the rare exceptions. So it seems to me, as I read that we're supposed to look at this categorically and the risk of incorrect determination categorically. Do you agree with that?
I do agree with that, Your Honor. And I at the same time, I think that the experiences of our clients can prove helpful illustrations of the risk of error inherent in the process. So
well, we know, don't we, that I think that OIG identified 1,700 something tainted cases.
Yes,
is that right?
Yes.
And it looks like either in the ones that they found there was sufficient evidence in the record, irrespective of the tainted forms, that when you look at the overall mix, way over half, the claimants are still retaining their benefits. I mean, that's the number's not in the record. Our math is like 65%. I don't know if that's the exactly correct.
Well, the government would be in a better position to provide the exact number, but I understand that they've said that it's about 55%. But either way, the court also held in Matthews that bare statistics rarely provide a satisfactory measure of the fairness of the decision-making process. So even if ultimately the rate of success is similar in this process to the rate of success in initial determinations, that doesn't mean that the risk of error in the category of cases is permissible from a due process perspective. And so even if people were able to have a complete medical file from the preceding 12 months, that's not guaranteed by this process. And so the risk of error is not necessarily reflected in the ultimate statistics in this case. And I think that in addition to our clients, the risk of error can be shown through the Hicks case as well. So in our case, for example, Mr. Kirk and Mr. Taylor have both been found disabled in their new applications. They just weren't able to show that for the period at issue. In the Hicks case, some of the plaintiffs had passed continuing disability reviews and they still failed in their redetermination hearings. So even though those aren't perfect corollaries to or perfect analogies to the redetermination inquiry, they do show that there is a risk that people who are legitimately disabled are unable to show that they were legitimately disabled during the redetermination process. And that's where that risk of error comes in.
Given that, if I'm reading Matthews right, and assuming for a minute we're under Matthews, we're balancing sort of this risk of error against the cost of additional process. So I just want to, I worry that some of the briefing in this case and some of the other cases were doing that balancing on an assumption that we were talking about something more like mini trials, a right to put an OIG witness up on the stand and cross-examine in every case. But you're saying, I just want to be, that's not what we're talking about.
That's not what we're talking about here. Most fundamentally, we would like the opportunity to object to the fraud finding.
Okay.
The plaintiffs don't have the ability to object to the fraud finding. And so that during.
So like motions in limine is sort of what we're talking about.
Correct.
Okay.
Correct.
So in the same proceeding, you're simply saying you just want to have an opportunity to present your objection.
That's correct, Your Honor.
And, okay. Speak, I don't know if the judges want, go ahead, Judge Qualabon. I was about to ask.
You go ahead.
Yeah. No, go ahead. I was going
Okay.
to shift to the APA, but I want you to go ahead and finish with this.
Okay, I got one last question on this matter. Tell me why this case isn't like Scheffler, where categorically polygraph evidence is excluded. It might be in certain cases the only available evidence, and it's excluded. I think that there was maybe in the Sixth Circuit trial, or maybe the district court proceeding in Hicks, or maybe it was at the circuit court, there was a distinction that said, well, those are categorical type rules, and here they're not. But I don't think that's right. I think here there's a categorical exclusion of the forms. There's then a individualized assessment of whether there's enough remaining evidence to support the disability. So how do you distinguish between Scheffler, which is deemed to be okay, and this situation, or Scheffer?
Yes, Your Honor. There are two distinctions. First, the SSA has not declared that there was a categorical exception. We don't know exactly why cases were identified as falling within this reason to believe framework and why they weren't. So it's not that every single case affected by Con Doherty and the doctors was swept up in this OIG inquiry. We don't know what their criteria were. My colleague just said in opening that they identified the RFC forms that matched the template RFC forms. And we don't know what criteria they used in matching either. So it's not a categorical exclusion, but more fundamentally, in a more general sense, this would be more like saying, even we know that polygraph evidence is excluded. We would like the opportunity to show that our evidence is not polygraph evidence. And so in this case, to explain, we know that all evidence where there's reason to believe it was fraudulent needs to be excluded. And we're saying that the individual aspect of that determination, that there was reason to believe that there was fraud in our case, we should have the opportunity to argue that individual aspect of the case. So
you've got about a minute or so left here, and would you briefly just address, you've asked us to apply this APA formal type adjudication procedures when, in fact, we know these proceedings tend to be informal and non-adversarial. So speak to that very briefly.
Yes, Your Honor. And for the APA, the more straightforward claim is the arbitrary and capriciousness claim, which is that the agency provides an opportunity to rebut the fraud finding when it's made by an SSA investigator, and they don't provide the opportunity to rebut the finding when it's made by an OIG investigator. And so the agency refuses to treat like cases alike, which is arbitrary and capricious. In terms of formal adjudications, this court has previously held that, in general, SSA hearings are formal adjudications subject to the formal adjudication requirements. So even though they're non-adversarial, they still are required to comply with the requirements for formal hearings. And redetermination hearings are indistinguishable from initial determination hearings for those purposes. So following that syllogism.
I've got your answer on that. I'll ask the judges. Your time is about up, but I'll ask the judges, do you have any further questions?
No, thank you. Appreciate your argument.
Thank you. Thank you, Ms. Stewart. We'll go back and we'll hear from you, Mr. Pullen. You have a few minutes if you choose to use them. Proceed.
Thank you. Sorry, I had to unmute, tripped myself up there. There's a few points I'd like to hit here. One, I think we got to an important point during opposing counsel's presentation about what do they hope to establish in these procedures. And what counsel said was that, there may have been fraud elsewhere, but there was not fraud in my particular case. The statutory standard doesn't require evidence that there was fraud in a particular case. It requires reason to believe that fraud was involved in the submission of evidence. As Judge Rogers explained, that very low bar is satisfied by evidence of the overarching conspiracy among Kahn, Doherty, and the medical professionals involved. So this goes
Was it your understanding, and do you understand now that what they're asking for appears to be rather limited, not a full-blown hearing, but an opportunity to rebut, which could be, as Judge Harris indicated, maybe a motion to eliminate or that sort of thing?
So I'm happy to hear that they've retreated from their initial request.
I don't want to speak to your happiness. I want to know, was it your understanding that you were arguing against something greater than that? And now that you know that it's a more limited situation, how do you respond to that?
I think it still does not, the weighing of the three factors under Matthews still would not guarantee even that reduced procedure. I think related to some of the reasons I was just getting at, which is that there's no reason to believe that even this kind of reduced procedure would materially affect the risk of error. The Supreme Court in Cayley, when it was applying Matthews to a kind of similar standard, a probable cause standard, said, this standard is just so easily met that having an adversarial process, while generally adversarial processes are kind of helpful to the truth-finding process, here the difference is too slight to support a constitutional requirement. It's not going to make a practical difference.
Judge Harris,
I mean, it is all a balance, right? And now we're talking about very low costs, and I don't see, why wouldn't it be sort of appropriate, even if it's going to be the rare case where someone could show there's no reason to believe there's fraud? I mean, if someone can put down in their motion my RFC attached a lab report, right? The way the SSA interprets this, it's going to exclude not only the fraudulent RFC itself, but also if it attached like a lab report or blood work or something, that's getting thrown out too. Why not let someone come in and say, look, here's the information about the lab that did the blood report. I think this is pretty reliable, and let the ALJ make a decision. Or, I saw Huffnagel as my personal physician, and I sat there while he filled out the RFC, and I watched him do it by hand. It wasn't from a template. Like, what? Why not?
So a couple of things with respect to kind of the lab reports. Those wouldn't be excluded here. They would come in because they could be obtained from the provider itself as part of the normal development process. It wasn't. It did not happen in this case, and it hasn't happened in other cases that the plaintiffs have pointed to, where there were these types of lab reports or some externally provided reliable source that could be provided.
Am I misremembering the SSA didn't come up with a whole separate rule to say specifically we're also excluding the attachments to the RFC? Did I just get that wrong?
The attachments, and there's one in the record at JA 280. What it was a narrative report provided by.
No, that's not what I'm talking about. I must have misremembered. I thought that, and I cannot find it, of course, in front of me, but I thought that there was a separate thing in the Federal Register that said, as we apply this rule, we're also going to be excluding like outside lab reports that were attached to these things. No?
It would be. So if one happened to be attached, it would be excluded, but then it would come in through the lab that conducted that report. So only kind of that copy. What was the big deal about? Then why did they have to put out a whole separate Federal Register notice saying we're excluding it if it's going to be included anyway? What was the point of that? I don't know that there was a Federal Register notice. I'm not exactly. I apologize. I'm not sure what Your Honor's referring to. But there is some rule that says we're excluding them if they're attached to a con-affiliated RFC. But you're telling me that doesn't matter, that rule has no effect because they're coming in anyway. We were just spinning our wheels on that one. If it could be, yes, it could be obtained through, no, what they were excluding was when it was submitted by con, and signed by one of the doctors. When it could be obtained, the same report could be obtained through an outside source. So
your time is up. Your time is up. But Judge Qualibon, did you have a further question?
No, I'm fine.
All right. I want to thank both of you.
Thank you very much.
A fairly unique setting, but I think you've done well under the circumstances. We well understand your arguments, and we hope to be able to respond in a fashion that reflects that we've considered it fairly. Thank you very much.
Thank you.
Thank you.
Usually we need some time in order for the next folks to set up, but I need to ask my tech people, are we in place?
Should be in place, Judge Wynn.
Because it looks like we're in place. So if we're in place for the Edwards versus CSX case, the counsel here, I will ask the
All right, thank you, Your Honors, and may it please the court, truly is a privilege to be here. I'm Bill Cash. I represent the appellants, Jimmy Edwards, and the rest of the putative class members. And I plan to divide my argument into two halves, the third-party contract issue and the federal preemption. And unless the panel has any leanings on this, I intend to start with the contract question just because I think it's an easier way to introduce the facts. So in our view, there are two contracts at issue here. The 1978 tri-party agreement that was made between CSX's predecessor, the City of Lumberton, and the Drainage District. And the second—
Let me ask you a question right from the beginning. It just bugs me about this case.
Sure.
Why didn't the City of Lumberton bring this case?
I believe the City of Lumberton didn't want to get crosswise with CSX and was hoping that the railroad would actually make good on its promise to build the floodgate, and therefore just didn't want to be a party to the lawsuit. That's.
I kind of understand how things work down in Robeson County a little bit, and I think I understand, but I sort of figured that, but I didn't want to just on my own. I thought you might give me a more definitive answer, but it sounds like you just don't know.
Well, I have an inclination, but I don't want to state that.
No, don't do that. Let's stick with the law. Go ahead and proceed.
Okay. So we've got two contracts. We've got the one that is attached to the record. We have the second agreement that we haven't yet located in writing, but it is part of the state report where CSX has promised to build the permanent floodgate. I'm going to lump those contracts together. Yeah, of course.
Mr. Cash, if I could kind of get to a couple of specific things I wanted to know. I'm not going to ask you about the second contract because, to be honest with you, anyway, I'm just going to focus on the first contract. If you could, and if you need to come back with numbers in your rebuttal, this is fine. But I'd like, it looks to me like the paragraphs that arguably relate to the intent to benefit the third parties are paragraphs 63, 64, 200, 234, and 235. And I'll be glad to repeat those. This isn't a gotcha sort of thing. But if there are things I'm missing, I want you to point those out to me, please.
Your Honor, I did not write down all of those, but if I can get to it this way, in our view, to look at the contract in isolation was a mistake. I believe our complaint does reflect that the third-party agreement was a necessary component of constructing the levee. The Jacob Swamp Improvement Plan was conceived in the late 60s. When you look at that plan, it's apparent that the levee would work if the gaps were filled in. So that was known on the scene all along. It was always the intent when the levee was designed to have the gate be closed. The contract was negotiated after the levee was completed, but it was on everyone's mind that this was going to have to be built. There was going to have to at least be the provision for a temporary berm across the levee, or it simply wasn't going to work. We certainly have evidence of that. We have documents from the Soil Conservation Service. We have reports showing that was contemplated. And there's a report from the Soil Conservation Service that shows the specific zone that would actually be protected by the levee if the levee worked. So getting the railroad.
I'm assuming from your answer to Judge Quattlebaum's question, what you are now stating are in fact the statements that you allege would show that benefit, the intended benefit here. If I'm understanding Judge Quattlebaum's, he was trying to identify the specific areas in which you say that this benefit arises so as to make it a third party beneficiary.
Well, and correct me if I'm misunderstanding that question, Your Honor, but the whole purpose of the system was to protect this defined zone, the South and West Lumberton area. The city memorializes that in the 1979 operational procedures where they talk about.
But that's in every contract like this, isn't it? And in every contract that comes up, the purpose is to protect somebody. And are you saying that in every case like this in which you've got specific areas, I mean, no matter what the city, usually when they enter a contract, it's probably not the entire city. There's probably aiming at a specific area or a primary area. And you said in those cases, the residents or the people from there are always third-party beneficiaries in that contract and can bring it to the exclusion of the city and everybody else?
No, not necessarily. And I mean, the case law does make a distinction between the cases where there's a general contract that's designed to provide sort of general
Looks like you froze on me a little bit there. You might want to restate that. Restate what you just said.
Okay, you hearing me now? I'm sorry.
Yes.
So there's a distinction I would make in the case law. The Maternus case, for example, involves contract involving interstate port, and the third party, the putative third party beneficiary claimants failed there because the court found that highway maintenance was just too general and too attenuated to where people were to permit them to enforce that contract. We believe our case falls into the other category of cases where utilities, like gas companies, like water companies, are providing a specific service to a specific area, and therefore those residents in that particular area do have standing. And I think it's the.
Can I ask you a question about those cases and the way you just described them? Because this is something that I'm trying to wrap my head around. You just said these are cases where utilities are providing services to a specific set of residents, and so you would think those residents maybe have a right to enforce the contract. But this case is different, right? Because this isn't about the railroad company's services. Like in those cases, it's the gas company falls short of the services it committed to provide. And so I could understand why in those cases you might sort of construe third-party beneficiary status kind of generously. But the equivalent here would be if like the suit was that the rail residents, for free, and then stop doing that. But this is not about the railroad services. So it seems to me it falls a little bit outside those cases you're talking about. But I want to give you a chance to address that.
Well, I think that's a fair point. I mean, this case doesn't involve the people of Lumberton trying to use the railway. But this is a case where the CSX specifically contracted to provide a flood protection service. It provided a license to the city, permitting the city to close the berm, close the rail line, and that was for a specific purpose, to benefit the people that were in that area. And so CSX did, I think, while this isn't exactly like Potter versus Carolina Water, for example, where the water company failed to provide water and therefore people's houses burned down because they couldn't get the water for fire protection. I think that's kind of the case you're getting at. Our case isn't exactly like that. But on the other hand, CSX did pick up this duty in the contract. CSX and its predecessor did promise to let the city avail itself of the ability to at least have a temporary burn, if not the permanent floodgate that was made in the second contract. So I guess
it just go ahead, Judge, please.
No, I'm good.
Judge Qualibon, you got a question?
Well, I was going to turn to a separate issue I was looking at in the pleadings. I didn't see any allegations about direct and active dealings between the third-party beneficiaries and either party to the contract as it relates to this issue. Number one, do you believe that's a requirement for a contract like this one that doesn't name the third party as beneficiaries? And if it is a requirement, did I miss it in the complaint?
Your Honor, we did not miss it in the complaint because we do not believe that that is a requirement for third-party beneficiaries to demonstrate. And that test comes from the Hospira case. And Hospira does say that the presence of active and direct dealings between parties would be evidence of an intent to create standing, but it does not hold that you have to have those continuous and active dealings in order to establish third-party standing. And so we just think that CSX is misreading that case, and that's just not the law. So that's our view on that. We didn't intend to put that in pleadings, and it's not there. I don't want to chew up all my time on the contract issues, but I want to make sure I'm not leaving anything aside before turning to preemptive.
I still want to return back just one little small point at the beginning, maybe and just because I'm fuzzy on the procedure and what's going on here. It looks like to me something really wrong is going on, but I'm wondering, don't these plaintiffs, would they not have, other than sovereign immunity, I guess, couldn't they force the city to do something if they failed to carry out a contract for their benefit? And they say, well, you won't go and get the people for the very benefit you got for us. Is that not something that can be done there?
Well, that's a possibility, Your Honor, but I believe that's a little outside the scope of our case here.
I understand it's outside the scope of it, but I'm trying to get you to somewhere where you might get some remedy for it. So far, you've got no remedy, but it seems to me that's the more direct way to deal with this. But if it exists, I mean, in terms of saying a city fails to do something that it's contracted to do and won't do it, at that point, you know, we got all kinds of other means by which one can do it. Even the state of North Carolina might be able to get involved in it from the Attorney General's office, where the city fails to carry out something it's supposed to do. But I'll let you move to preemption, since I know you didn't come here to argue that. But I'll tell you right now, it's bugging me as to how it is that the city, in which these people are part of, will not proceed against an entity for the benefit of this group of citizens. It's interesting to me. And now they have to come in and say, we are beneficiaries. And as beneficiaries, we can do something the city, which is a contract, who we are part of, won't do. But go to preemption. Go to preemption.
Your Honor, just to respond, I'd be reluctant to cast aspersions on the people who run the city of Lumberton or the Public Works Director, and some of those questions kind of implicate the political process. I'd be reluctant to overstep my bounds.
I'm just talking law. I'm talking law, not in terms of whether or not sometimes politics. We get into this thing about things being personal. There's nothing personal here at all. I'm talking about people who are trying not to have their places flooded.
Yes, sir.
I don't know. That has no politics in it to me. I understand people will be political about it, but you do what you go ahead and go to the print.
Yes, sir. Okay, so as you're aware, our tort claims were dismissed on preemption grounds, and just getting straight to the heart of the matter, we believe it was error for the district court to grant the finding of federal preemption on a motion to dismiss. There was no evidence in front of the district court on which it could make that ruling. The Green Mountain test which says that tort claims are preempted only if they unreasonably manage or govern railroad operation. That's the binding test. In the Fourth Circuit, in the Third, Second, Fifth Circuits, the STB itself follows the Green Mountain test, and the district court blew past it by not permitting us to put in any evidence of our particular remedy, and by not making CSX put in evidence of how exactly our preferred remedies would have interfered with its rail operation.
It interferes whenever you got to close it up. If you got to close it up, that interferes with the operation of it. Isn't that it? Y'all asked for the same kind of relief to have the railroad to change its operations.
Well, I have several responses to that, Your Honor. So first of all, the thing that actually closed the line here was the flood. And, had a temporary berm actually been permitted to be built the way CSX agreed to in its contract, that would have actually preserved the railroad's ability to get back in business later. And there was no cost for the railroad to permit the temporary berm to be put into place. We were going to pay for that, or the city and the state were going to pay for that. There was an army of volunteers that wanted to pay for that. And there would have been no burden on railroading because there is no railroading going on in a flood. We put the picture of the flooded rail line in our pleadings for a reason. Secondly, as the STB has held, when a carrier actually commits to a desired remedy in a contract, that is very strong evidence that the remedy itself will not be a burden on railroading operations. And that's exactly what happened. In the tri-party agreement, CSX's predecessor said, yeah, if there's a flood coming, you can go ahead and build a berm across our line. It was wrong for the district court to then come in and oversee.
I'm sorry, I think that maybe I'm misunderstanding something about kind of the structure of your argument. I can see how questions about how burdensome this would be relevant to an implied preemption analysis, but are you saying that the state can expressly regulate railroad operations, and unless there's some burden that the railroad can show, that's 100% fine? Because that was not my understanding. I thought that for express preemption, all that matters is the state effectively regulating railroad operations.
I think we're probably saying the same thing here, Your Honor. The test is whether the remedy is going to unreasonably manage or govern.
No, we're not saying the same thing. That's as far as I had read the law. The unreasonable part of that is something we do when we're talking about implied preemption. If there's no actual express, direct, non-incidental regulation of the railroad, then we go on to say, okay, fine, this is just a general flood control measure, but we'll ask whether there's an unreasonable burden or interference. But if it's just the state saying, look, as a matter of state law, you got to shut down the railroad tracks 24 hours before every storm, that sure sounds like just express regulation to me, and I'm not sure the railroad has to show that it was burdened by that.
In a case where, as here though, the railroad committed to doing that, I think you pretty much can skip that.
Only if burden matters. I don't think that the fact that the railroad sort of agrees to do it, it seems to me, I'll let this go in a minute, but I really am confused as to kind of what box we're in, express or implied preemption. Is it your position so that the state could in fact pass a law saying from now on, if there's a hurricane that's been forecast by NOAA, 48 hours before it's supposed to cross, we're shutting down the railroads? That would not be preempted in your view?
No, that is not our position.
That would be preempted.
I believe that what takes.
Okay, so how is that different from 48 hours beforehand, we're going to come put sandbags across your railroad line?
I think the most obvious issue here is that the railroad agreed to let that happen. And I would say that.
Okay, what if the railroad doesn't agree? And I think they don't agree because they're right in the box next to you.
If the railroad hasn't already agreed in a contract to permit sandbagging, which is not the case that we're in, and the state wants to pass a statute that just says we declare these following standards for flood control in the future, and they apply it specifically to railroads, I do believe that would be preempted.
I think you're convoluting contract and preemption. If you want to enforce the contract, the parties need to come to the table and do it. And you've already argued that part about it. Now we're talking about preemption, which from Judge Harris' position, when you're talking about the reasonableness that you're dealing with it, it's a totally different situation.
If I may briefly respond.
Well, why don't we do this? Your time is up for right now. You got some time reserved, so that'll give you some time to think about it, and then come back with rather than off the top of your head. You might like us better for that. How's that?
All right.
All right. So we're here for the other side a little bit.
Good afternoon. May it please the court. April Ross on behalf of the appellee CSX Transportation. Your Honor, CSX is a private railroad company. Its business is the interstate freight transportation by rail, and the rail tracks at issue have run through Lumberton, North Carolina for over 150 years. A century after those tracks were built, the government built a stretch of Interstate I-95 running through Lumberton. I-95 sits on an elevated berm and has bridges where it intersects roads that pass underneath the highway. When the government built I-95 in Lumberton, the new highway happened to intersect the railroad tracks that have been there for a century, and also a two-lane public road that runs adjacent and parallel to those tracks. What appellants refer to as the CSX gap is in reality simply the area beneath the highway bridge, including that road and the railroad tracks. You can see it in the drawing at Joint Appendix 68. It's about 90 feet wide, including the road, other land, and the tracks. Tracks cover roughly a third of that distance. CSX did not create this gap, did not choose its location. It's just a highway structure built by the government a century after the railroad tracks were laid. Your Honors, this case is about two historic natural disasters, and it's about.
Well, let me ask you on that. You're saying it's not the railroad's gap; it's the highway. It's the state of North Carolina's gap.
That's correct, Your Honor. It is simply that.
So you're saying the state of North Carolina could close this gap if it wanted to?
The state of North Carolina, Your Honor, could not close the CSX tracks on the gap because of the same issues we're talking about with regulation and preemption. They would not be able to halt the movement of trains. They could certainly close, the road and other areas of that, but no, they would need permission from the railroad or from the Surface Transportation Board to dictate when trains can run through Lumberton, which is precisely the issue.
Tell me, let's go to the fundamental question here that kind of bugs me. Why wouldn't the railroad want to close that gap? It's going to flood that community over there, and it has. It caused great devastation. And I'm just puzzled as to why in the world would you work with to not have this devastation. You're right in hurricane season now. In a moment now, one of these things could happen, and I've seen enough of what goes on in eastern North Carolina, that area down there, that this is real. And it is almost unbelievable that the railroad would when someone come in a dire situation about to have the place flooded, and they said, "Oh no, we're not going to do it. We're preempted. Oh no, we're not going to do it because nobody else tells us to do it." Now, I agree. I'm miffed as to why the city of Lumberton and others don't jump in this, but you don't need to go there. We've already hashed that out because that's going nowhere. But what is this about? I mean, is it just the operations that they've got the prerogative to do it?
Your Honor, I think it's two things and maybe more, but it's certainly the operation of the railroad, the need to continue to move freight, to move trains, and sometimes that can involve the need to move freight and cargo outside of the area on the other side of what would be the barricade, move that to a safe location, which is part of the railroad's operational responsibilities. The second is that to do that places the railroad in the untenable position of deciding which area of Lumberton, for example, would be subject to flooding. What we have,
but we are talking about a flood here. Let me just ask you. I always think about a case like there's no way you can get together the parties here and work this thing out. I mean, this does not look like a good public relations situation at all. I mean, it looks horrible to me in terms of what's going on, and I just don't know. I'm wondering why a company would not want to take at least some measures to help the situation. May not give them everything they want, but at least give them some comfort that, hey, when that flood comes through, it's not going to rush over there and flood your property. Is there no opportunity for that here?
Your Honor, as is alleged in the complaint and as reported in various media reports, the local governmental entities and the railroad have been talking for some time about coming up with a solution for this area.
So you are working on a solution now. That's all I need to know, that you are thinking about it other than just coming to the court and says, we're not going to do it because we're not preempted. There is something going on here that we could possibly get a notice from you any day. It says, hey, we sat down and we put a couple of adults in the room and decided that we settled this matter here, and everybody's going to be good. I'm not being facetious about it, in the purest. I mean, I'm really concerned because of what this case. It looks really bad. I mean, it can't look good for the railroad at all, and I don't know. I don't know all the. I don't need to know all the other politics involved. I know there's something here, but it doesn't make any sense to me. But
Your Honor, my understanding is that there are discussions underway and have been for some time about a longer term solution for this. The question, though, in this case is not really that. The question is one of enforcement of this 1978 contract by these appellants, and it's one of the use of state tort law to direct the running of trains and the building of tracks. Yes.
Judge Qualibon's got a question.
Ms. Ross, just on that note, when you were answering a question earlier, you talked about the objection really relating to the operation of the railroads. And I guess, I understand that to some extent, but we've talked about the city a lot, and it's not a party, but I mean, it doesn't sound like you are disavowing the contract. And the city, as a party to the contract, in theory, could have sought to enforce its rights under that contract. Is it your position that, I get the third-party beneficiary argument, so I'm not talking about that for right now, but I mean, the city had every ability to enforce it, or are you saying the contract somehow is null and void?
Your Honor, well, the plaintiffs have alleged that there is a contract. I'm going to set aside the second contract for a moment because they
me too.
Alleged that contract. With respect to the contract they have alleged, what that contract does is one thing. It's a limited licensing agreement from 1978 that it would allow the city to build an earthen dike on the railroad right-of-way. And if the city builds that dike, it would allow the city to extend the dike in the event of flood.
Where does it say I know your argument, and it sounds like that's that argument that it sounds more like a condition precedent argument. I understand exactly what you said, that the agreement gave the city the license to build the earthen dike. I didn't see a time period on that, and I didn't see the if it does so part of that contract. And so if I missed the if it does so part of that contract, if you could point that out to me, I'd appreciate it.
Sure, Your Honor. If you look at the joint appendix, page 57, in clause 8A of the agreement provides.
I'm looking at it.
Provides the city shall have the right of closing said dike across the track. The issue here, Your Honor, is in part that the dike was never built based on the court cited by the appellants in their complaint. The city never performed the original condition of the contract, and therefore CSX was never obligated to do anything.
You keep calling it original condition. I mean, I suppose the plaintiffs are saying we were effectively sandbagging up the other portion of the gap, or trying to do so at that time. I'm still having trouble with the condition as you describe it. It looks to me like those are separate rights and obligations under the contract.
Your Honor, I disagree respectfully with that. I read the contract as allowing for the consideration of $1 access onto railroad property to build a berm with very specific specifications laid out in the contract, as well as the attached drawings to that contract. And then if that berm is constructed, to allow the city to extend the berm in certain occasions. It doesn't require CSX to do anything, build anything, block anything, protect anything.
Right.
We've talked about the third-party standing issue, but even if the plaintiffs had standing here, it doesn't require CSX to do what they would have CSX do in this occasion. But the issue really more fundamentally is that these plaintiffs do not have standing to enforce this contract. This is, as the court surely knows, contracts are normally binding on and actionable by the parties to the agreement, and that there may be limited circumstances that give rise to third-party standing. But under North Carolina law, there is a strong presumption against third-party enforcement of contracts, and the contracts are strictly enforced against those non-parties. And here, what we're looking at is a government contract, which has an even stronger presumption against enforcement by members of the public. And as the North Carolina Supreme Court stated in the Maternes case, a third person cannot maintain an action upon a contract merely because it would receive a benefit from its performance or because he was injured by the breach thereof. Every public contract by its nature has in mind members of the public who may benefit from performance of that contract. It does not mean that every member of the public in perpetuity would have the right to come to court and have standing to enforce that contract. And that's what we're talking about here. Yes.
Let me, if I could follow up on that point, and your colleague mentioned earlier, I think accepts that general principle. This contract, though, it appears obvious that the beneficiary, that to the extent the public would benefit, that it would be the people immediately, adjacent to the area. So if you could respond to the distinction your colleague made earlier about, say, a road construction contract where the people who go over it would be maybe random or more random, and this where if it was to be built, I get the pleading deficiencies. I'm not sure this ultimately matters because I'm not sure if it's pled or not. But I wonder whether a contract like this requires that level of specificity when it's obvious who would benefit from it, and it's the adjacent landowners.
Your Honor, I think it does. It doesn't require necessarily the naming of Mr. Jimmy Edwards, for example. But what we have here is a very amorphous definition of the class of persons that would be protected by this contract. And it appears by appellant's position to be anyone in the south or western part of Lumberton at any time, living there, working there, moving into that area decades after the contract has been signed, who would then apparently have standing to come and enforce this. And when we look at North Carolina law on third-party beneficiary status, what we see is the court repeatedly finding no third-party beneficiary status in cases where there is a much closer relationship between the parties. So, for example, in the Holshower case, the Court of Appeals found no third-party standing for an assaulted employee of a hotel who sought to enforce the contract between the hotel operator and the security company, who was intended to protect her while on the premises. In the Vogel versus Reed Supply case, we have the North Carolina Supreme Court finding no third-party standing for a landowner who sued the subcontractor because any benefit to the landowner would accrue indirectly through the general contractor. And here that's what we have. Any benefit to the members of Lumberton or the residents of Lumberton at most would accrue indirectly through the city, not through CSX. So there is no standing to sue CSX to enforce this contract, which plaintiffs do not have a direct beneficiary relationship to. Your Honor, I want to make sure I've answered your questions on the contract, but I would like to make sure I have time to address the preemption questions. I would quickly like to touch on the public utility argument first, only with respect to the contract, because I do think, as Your Honor's pointed out, and as Judge Harris pointed out, there is a significant difference between a railroad running a freight operation and a public utility providing a service specifically for the residents of the community. Here, CSX's business is running trains, not providing services to these people. So turning then to the tort claims, what appellants seek in this case is to have the district court dictate when, under state law, trains can run, when the tracks need to be barricaded, both temporarily or with a permanent structure, to require CSX to build a permanent structure that would cross its rail tracks and be used in times of flooding, and to require CSX to rebuild its tracks using a different and less porous material. The court concluded below on the face of the complaint that will interfere with railroading. It requires the digging up of tracks, the building of structures, the changing of materials, the stopping of trains. This is the core exercise of the Surface Transportation Board. And 25 years ago, Congress vested this. Yes.
Look, I think you make some good points to a lot of the claims for relief that are alleged. But one of the claims is just to allow the city to come in and sandbag the area of the right of way. And that relief, appears to be generally consistent with the contract that's the tri-party contract that's been pled, which on that relief alone, given that there's at least an allegation that you've agreed to that relief in contract, can that be preempted? Is that preemption if you've already agreed to it?
Your Honor, yes, with respect to the tort claim, we don't take the position that the contract claim is preempted, and this court addressed that issue in the PCS phosphate case with respect to private agreements. But with respect to a tort claim that seeks to require CSX to allow barricades to be put on its tracks, to use state negligence law to enforce that, yes, it's our position that is preempted because it interferes with railroading. And Your Honor, this case is not unprecedented. This case is precisely the same as the Katrina case from the Eastern District of Louisiana, which was dismissed on the pleadings. And that case, like this, involved a devastating flood following a major hurricane. It involved local residents suing CSX, where CSX's tracks intersected with the city's levee system, claiming that the materials that CSX used and the way that it conducted its operations increased or led to the flooding of the lower Ninth Ward in New Orleans. There, Judge Duvall found both that a railroad does not have a duty to protect the public from natural disasters, but also that those claims are preempted by the Interstate Commerce Commission Termination Act. And the Pere-Marquette case reached the same decision. And I refer the court to the Iowa Supreme Court's decision in Bricklyon versus Rapids, which very nicely summarizes law on the Interstate Commerce Commission Termination Act and flood-related preemption. I do want to touch, to make sure I have time to touch briefly on a couple of Surface Transportation Board decisions that appellants have latched onto and claim support their claims here. In particular, the Holly Acres related decisions. These are two decisions issued by the Surface Transportation Board in a case involving CSX and flooding of a mobile home park in Woodbridge, Virginia. There, the Surface Transportation Board, despite what appellants say about these cases, did not find that the claims were not preempted. What the board found is that it did not have enough information about the underlying lawsuit and elected not to rule on that issue, and also noted that the law on ICTA preemption is clear and well settled and could be applied by the court, citing, for example, to the Katrina case, the Pere-Marquette case, the other cases that we've cited in our brief. And in Holly Acres, the board issued guidance to be used by the state court in determining whether preemption applies. And according to the Surface Transportation Board, The ICCTA prevents state or localities from imposing requirements that by their nature could be used to deny a railroad's right to conduct rail operations or proceed with activities the board has authorized, such as construction. Your Honor's, orders to barricade tracks, build temporary permanent structures on the tracks, or change the materials that support the tracks plainly fall into that category. And the other thing that the appellants leave out about the Holly Acres case is the end of the story. Once those cases were returned to the Prince William County Circuit Court, the court granted CSX's plea and bar, finding all claims were expressly preempted by the ICCTA. The plaintiffs attempted to appeal that to the Supreme Court of Virginia, which found no reversible error in the judgment. So that decision certainly does not help appellants and simply reinforces the reach of preemption in this case and its application to these claims. Your Honor, at its core, this is a case about whether the railroad is responsible for flood protections in time of natural disaster under state law. It's not. These appellants do not have standing to enforce this 41-year-old agreement. The contract is before the court and was before the court below. The complaint pleads no facts supporting third-party beneficiary standing. The contract does not support third-party beneficiary standing. And while the public might benefit from this agreement, that does not give rise to legal standing under North Carolina law. And even if they did have standing, the contract does not require CSX to do the things the appellants say that CSX should have done. With respect to their tort claims, those claims directly implicate areas of rail construction, maintenance, and operation, the building of tracks, the blocking of tracks, the shutting down of train operations. 25 years ago, Congress vested exclusive jurisdiction in the Surface Transportation Board for those matters, not in state court and not under state law. Courts routinely dismiss claims like these on the pleadings, where it's apparent from the face of the complaint they cannot proceed. There's no additional information, discovery, or fact development that's needed on these issues. It's apparent from the pleadings and the documents incorporated in the complaint that this complaint was properly dismissed below. Therefore, we ask that the court affirm the district court's ruling.
Thank you, Ms. Ross. Judges, do you have any further questions? All right, then, Mr. Cash, you have just a few minutes for rebuttal if you choose to use it.
Yes, sir, and I thank you. First off, Judge Quattlebaum, I tried to find paragraph numbers that I thought would support what you're looking for. If it's all right, I'd like to give you my list of numbers back. So I'd go with 26, 46 through 59, 63 through 68, 183, 234, and 235.
Thank you.
Sure. And with respect to Judge Harris's question on preemption, I guess I'd like to pick up with the Holly Acres decision as well, which I think is a good roadmap for this case. We treated it carefully in our briefs. CSX was being sued in state court. It didn't think that it would get its preemption finding in state court, so it ran to the STB as an end run around the judicial process. My colleague is correct that it sets out a good roadmap, but I think when you look at the decisions, it's clear the STB expressly considered there could be a construction remedy at issue in the case. The STB expressly declined to find express preemption on the pleadings, on the facts presented there, even though the plaintiff was seeking a construction remedy. And I think the key thing in both of those decisions, when CSX lost the first time and lost the second time, is in both instances the board said the ultimate preemption finding would have to turn on the facts and circumstances of the case. That is consistent, and it cited the Green Mountain test, by the way. That is consistent with our argument, not theirs, that you need to look at the facts and circumstances. You need to have evidence and information about whether the remedy really would disrupt rail operations or whether it would be incidental. And there hasn't been evidence in this record as to whether the building of a temporary berm would stop a single train in the event of a hurricane. Nor is there any evidence that the construction of a permanent floodgate could or could not be done without interfering with rail traffic. We've been doing construction on active rail lines for about 2 centuries. It is possible to do that without interfering with rail traffic. And even if it did, the law is that the interference has to be not unreasonable to protect these thousands of poor residents and to preserve hundreds of millions of dollars in damage. As the state report found, it might not be unreasonable under the analysis to stop a train here or there, but that should have been tested in the district court and not blown past on the pleadings. With respect to whether this is done on the pleadings or not, even CSX in their briefing said it's routine. but we cited the Massachusetts case pointing out that it is very rarely done, and the great majority of these decisions are made on a factual record and not made in a vacuum. So respectfully, I see I'm out of time. I want to ask this panel to reverse the decision below, reinstate all of the claims, and let this case go forward. I thank you.
All right, thank both of you. Thank you for your arguments. And as I said, we're very unhappy we cannot come down and personally greet you, but you get a nice wave from me. How's that? Be safe out there. Thank you very much. Court's going to stand in recess for just about 5 minutes or so before we proceed to our final case of the day. I hope I'm looking at the lawyers from the Young versus Antonelli case. Is that correct?
Yes, sir.
Good. We're ready to proceed and glad that you're able to visit with us. And as I've said to others, it's not really, it's a virtual format, but the court is real. So we're glad to have you here. Your panel today, Judge Harris and Judge Quattlebaum and myself, Judge Wynn. So this time we will hear from the appellant in this case.
Thank you, Your Honor. Let me just say briefly, unfortunately, the way I'm looking at the screen, I cannot see Judge Harris. So.
Here, can you hear me?
Yes, ma'am. Yes, Your Honor. If you raise your hand, maybe I won't be able to see you.
Okay.
Thank you, Judge Harris, and may it please the court. I'm Emily Harrell. I'm here today on behalf of Appellant William Young. The issue for determination by this court is whether United States versus Burrage, which was decided by the Supreme Court in 2014, is a retroactively available decision for individuals like Mr. Young who were sentenced under the mandatory guidelines. The government has not argued that Burrage itself is not retroactively available as it is for statutory cases, but rather their position is that it's not been held retroactively available for guidelines cases. And in this case, under this this court's decisions in Wheeler, Lester, and more recently Braswell, Mr. Young's position is that it is indeed available to him to use in this 2241 petition to open the savings clause so that he can have his petition heard on the merits. Under the Wheeler and Lester, the Wheeler test as applied in Lester, at the time of
sorry, this is Judge Harris interrupting. I'm sorry.
Yes,
just before we get to the Wheeler argument, there's a footnote in your brief about something I was having trouble understanding. The way the enhancement seems to be written in categorical terms, so that it only applies if the offense of conviction, right, that the, no, I can't find it.
The way that's written is that the offense of conviction itself needs to include the death results in language.
Right.
And there is some dispute among the circuits about whether that offense of conviction is language which is broader than the offense, or whether it's narrow, like offense of conviction, which would mean that he would have had to have been charged with the death results language in the indictment.
Okay. Is that issue not in front of us? I don't have to worry about that here?
No, Your Honor,
it looks
it's
sort of
not.
funny. Okay.
It's not, Your Honor. I was just trying to cover all the bases.
No, I appreciate it because I was confused by the language and what was the offense of conviction. Is it related to your waiver argument? Is this the argument that the district court thought was waived, the idea that this had to be charged in the indictment?
Well, my position would be it would not be my waiver argument, but to
your client's waiver argument.
Thank you, Your Honor. Yes, the government takes position, I believe, that Judge Curry's decision on what he actually waived was narrow like that, like the offense of conviction had to include that language. Okay. So that would appear to be what that pertains to. At the time of his sentencing, obviously settled law established the legality of his sentence. Before Burrage, there's no doubt that his sentence was legal. And the argument that his sentence was not legal would have been rejected via application of Patterson in this circuit. Subsequent to
Ms. Harrell, if I could interrupt you and just ask this question. I understand the argument that because of Burrage, that it would make sense that the same holding of Burrage would apply to the guidelines. I mean, the language is the same, if not similar, if not the same. So I get that argument. but to my knowledge, I was not aware that the Supreme Court or this court had held that the Burrage decision applies in the context of the guidelines. So if that's true, how do you meet the second prong of Wheeler? I mean, I can understand how someone would say that should be the case, and maybe that gets done, but how has that already been done by the time the district court is presented with this case?
Well, Your Honor, under the Wheeler and Lester test, it does not have to already have been done. It says the settled substantive law changed and was deemed to apply. Under this court's Thomas decision, the district court as well as the circuit court can make a decision about retroactivity. And so it does not have to already have been done. It just has to have been deemed be done at the time the court considers it. So our argument. Sorry, Your Honor.
Let me just follow up on that. And I think I get the argument that a district court could make a retroactivity determination. I've read that. I think I understand that. But but don't you still, for the law to have been changed, doesn't some court have to say that Burrage applies not just to the statutory provision, but also to the guideline provision? Doesn't that have to be done before the law changed? Or are you saying that's not necessary?
I'm saying that this court can make that decision. You say some court, this court can make that decision. And so
if we say that now, and this may be semantics, but if we were to say that in this case, let me back up. If this court is the one that's doing it now on appeal, does that mean the district court was right in what she said at the time? Because the district court can't change the law of this circuit or the Supreme Court. And again, maybe we do it now and make it all clear, but it seems like at the time the district court acted, I don't understand how the law had changed.
I think the district court had the authority to make the decision. She did not exercise that authority because she believed she didn't have that authority. And therefore, I think this court can make the determination, find that he's opened the savings clause, and the case can then go back to the district court for a determination of his case on the merits. I don't think, I think that's the what can happen. So obviously, Mr. Young would not meet the third element of the test because it's not a constitutional decision made retroactive by the Supreme Court. And I also believe, obviously, he would meet the fourth element of the test. The only element of the test that the government has argued that he does not meet is the second element of the test. And I think we've just discussed why he does meet that. So,
Ms. Harrell, if I could ask another question, moving to the waiver issue. I think I understand the district court's, what the district court was talking about. But is there something, do you have a citation in the sentencing transcript that supports the notion that all that was being waived is the argument that the elements needed to be set forth in the indictment and pled and proved at trial?
Your Honor, to be candid, I don't. Okay. I have read both of the guilty plea and sentencing transcript ad infinitum. And, and it is not clear to me in the sentencing transcript what the district judge questioned him as to what was being waived. I do believe it's clear from the guilty plea transcript what he was waiving. But when they got to sentencing, there was a lot of the use of this and that, and is that what you're waiving? And it's not clear to me, Your Honor.
No, I appreciate your candor on that. I thought it was more clear from the the better argument was from the guilty plea transcript as well.
Right.
Which brings me to two more questions, and I'll try to be quiet. But the number one, on the waiver issue, what is our standard of review on that? And if I caught you off guard and you'd rather do that on rebuttal, feel free. I'm not. This isn't gotcha, but given the uncertainty, that I think that may become important. Number one, do you want to wait till? It's perfectly fine if you prefer to wait.
Your Honor, to be candid again, I don't know what your standard of review is on a waiver issue. I had not prepared for that.
That's all right. Because let me then ask my next question. And it seems like, despite any, maybe whether or not it's ambiguous at sentencing, what does seem clear is that that your client appreciated that it couldn't prove the death was caused either by crack or heroin, and that might present some sort of a problem, either that they couldn't charge it or whatever. And your client, however, also knew that the indictment or that the government could go back and get an indictment for both drugs, and thought the risk of that outweighed making whatever objections existed based on this proof situation. Is the relief that you're seeking the benefit of whatever objections your client had back at the time without the risk of getting indicted for the offenses that would lead to a life sentence?
My position was that what he waived at the time was not a but-for argument, as is present in Burrage, but rather that to apply the sentencing enhancement, they had to go back and get this superseding indictment, which charged either both offenses or the death results. If we're going to say it's not clear from the sentencing transcript, either one of those indictments. And our position is that what he waived was not the argument that is now present in the Burrage error, but rather that the government had to obtain that indictment for them to apply that sentencing enhancement.
Okay, you have anything further you want to add before
I don't, Your Honor. Thank you very much.
All right, we'll hear from the government. You have some time for rebuttal. Proceed. Not yet. You're still mute.
I'd like to unmute you.
You there?
You're not muted over here.
Can you hear me now?
We can hear you. Proceed.
All right. Thank you, Your Honor. May it please the court, Robert Bailey on behalf of the respondent, warden from FCI, Williamsburg. Let me just get straight to a few of the questions that were raised before. The test requires that the law be changed by either this circuit or by the Supreme Court. If you look at prong 1 of Wheeler and then prong 2, it's clear that although a district court perhaps or court of appeals can decide on the retroactivity issue, the change in the law has to come from the circuit or from the Supreme Court. And clearly,
am I still invisible? Sorry, this is Judge Harris.
No,
can I still not be seen?
I can see you, but you're frozen, but yes.
Yeah, great. I don't know what's going on. I'm sorry. You can hear me though?
I can, yes, ma'am.
We hear you
so
quite well,
in
Judge Harris. Proceed.
Okay, good. Sorry. In Lester, I feel like that would have been a good argument before Lester, but it's not really consistent with Lester, because in Lester, to find the change in law, we pointed to 11th and 4th Circuit cases on crimes of violence, but they didn't arise under the same guidelines provision. One was under a statute and one was under a different guidelines provision. And we just said, close enough, like we're going to drop it down into this guideline provision. So that seems not really consistent with the argument you're making and more like the argument the defendant is making.
Well, in both Lester and in Wheeler, that wasn't even an issue. So clearly, it's kind of hard to call it a holding if that were to be the case.
Well,
and
I don't know about that.
But
okay.
But just as importantly, the court did look to find where the 11th Circuit and 4th Circuit, depending on which one applied, had actually taken the Chamber's decision and applied it below. And in that way, we don't have anything like that in this case. It would be a weird instance to say that the district court erred in failing to find that the law had changed only because the 4th Circuit might now decide to change the law or apply Burrage to the guidelines. It would.
Well,
yes,
Mr. Daley, assume you're right for the sake of discussion. I mean, yeah, even if the district court may not have erred at the time, could we not do it now and then send it back for for proceedings consistent with that?
I would never tell you that you don't have the power to do that. You certainly do have the ability to rule on that issue if you determined that it was within the scope of the issues raised. If you were concerned about whether you should decide that Burrage applies to the guidelines, I would want to point you to a few places in the Burrage opinion itself where they're clearly focused on the fact that this is a statutory sentencing enhancement that they are interpreting. The Supreme Court made that pretty clear. Towards the end of Justice Scalia's opinion, he talks about the fact that this but-for causation makes sense and really is necessary in the context of a criminal case, a case where it's a criminal statutory enhancement, because a lower standard would create a certain level of uncertainty, he thought, that did not square with the reasonable doubt requirement of obviously a trial. And then if you look at the concurrence of Justice Ginsburg, you'll also see that she says things can mean different things in different contexts, but in a criminal case where it's a criminal statute, where the rule of lenity would apply, we think that when there's a close question, it's going to need to err, you're going to have to err on the side of ruling in the defendant's favor. And so what's really a little bit different about...
But under Lester, where we said that the pre-Booker guidelines were going to treat like statutes effectively because there was no discretion, why would that make a difference? I mean, I can see why it might make a difference post-Booker, but why does it make a difference pre-Booker?
Because you didn't have to prove the enhancement to a jury beyond a reasonable doubt. You just had to do it by a preponderance. And so there's certainly a lesser standard that you have to prove. And it might be that in a sentencing context, the substantial or contributing factor test or the proximate cause test might be enough. Obviously, that hasn't been briefed here, but that was what was being discussed in Burrage in the context of a criminal statutory enhancement, which clearly is different, as Justice Scalia talked about in the Burrage case. So the other thing that would be important to recognize is that when you look at this 2241 test, it can't be that a district court has to predict into the future how decisions might be applied in other contexts. As obviously all of y'all know, that the court has continued to say that you're supposed to construe 2241s narrowly. You're not supposed to just open up the floodgates. And so that would be consistent with not deciding that we're going to go ahead and say anywhere where we might apply Burrage, we're going to go ahead and tell the district courts, you should have applied that back before we actually said it was so. Hearing nothing more.
If we held that Burrage did apply to this sentence, does that mean that his sentence then is improper and we should send it back?
I don't know that it would make a whole lot of difference, Judge, when you'd either say the judge was right, but we now find Burrage applies to the guidelines, taking your hypothetical, and maybe affirm her, but I would assume that Ms. Harrell would file a new 2241 within a few days, citing to your decision, because there's no limit on the number of 2241s.
How do we make sense? How do we make sense of the guidelines' repeated references to Section 841 if those provisions are to be applied differently?
The references to 841, I think, are simply to the statute, the drug statute. It's not specifically to the death results, because otherwise it'd be duplicative. That's the sort of strange thing. The reality is, I think in most instances now, federal prosecutors are just charging death results as a statutory matter. So that's why I think there's a repeated reference to 841, because that's the drug statute that all these drug cases gets prosecuted under. If you have any further questions on the second prong issue, I think that's the one you can decide this case on. I'm happy to answer those, but otherwise I'll move for just a couple of minutes to the waiver argument. I think it's pretty straightforward.
Oh, before we go, and this might actually be sort of a transition over to waiver, just on the fourth prong, if we were just assuming for a minute that the rest of Wheeler was satisfied, you agree that this would be a fundamental defect under Lester and Wheeler because he was sentenced pre-Booker above what should have been the maximum?
Lester makes that clear, yes, ma'am.
Okay, so if it's a fundamental defect under Lester, why would it be waivable under our, our cases involving appeal waivers and plea agreements? Isn't what we're talking about there very much like what we're talking about under the fourth prong of Wheeler? You're being sentenced outside the statutory maximum. So why would this be something that's waivable?
Well, it wouldn't be waivable if he meets the second prong.
Right. I'm sorry. Hypothetically, I'm assuming he meets the second prong, and then you agree that would mean it's a fundamental defect because he was sentenced outside of what we treat as a statutory maximum. So I'm just thinking about all of our cases on things that can't be waived, even in a plea agreement, and I'm wondering why this wouldn't fall within that.
Well,
how is there space between? Go ahead.
There's no. Again, if he meets the requirements of 2241, we're out of luck. And so waiver doesn't, I mean, so waiver, we don't win the waiver argument in that instance. But in this instance, back in the day, when this all happened, I am certain that the prosecutor, knowing what he knew, would have gone back. I mean, there's no dispute that
Wait, I'm
Mr.
sorry, so
Young-
are you saying, I thought that your waiver argument was an independent argument, that even if you lost under Wheeler, you still won because he waived it. But you're saying, no, if he satisfies Wheeler, we don't have to get to waiver. I don't understand your argument. You're not arguing that the Wheeler thing is something that can be waived.
If he wins
If
Wheeler-
barrage applies to the guidelines, we
Right.
can hold that barrage applies to the guidelines in this posture. It's a fundamental defect under Wheeler. Are you still arguing that it was waived?
I think that the fundamental defect is not identical to the requirement of a you've caught me sort of flat-footed. I'm trying to think. So, it's still not in this context it wouldn't be something that couldn't be waived because of the context in which it arose to start with, particularly where it's clear and there's no dispute that Mr. Young sold the drugs. It's just that we didn't indict him for it.
But that's
And
true.
so-
That's true in any plea agreement. The defendant gets something in exchange for the agreement, but we still say it can't be enforced on the back end if it would result in a sentence that's outside a statutory maximum, because you're just not allowed to waive your right not to be sentenced without statutory authority.
You just
It does. I don't want to hold
you.
you up. It's fine. I just wanted to make sure I understood the structure of your argument. It's fine.
Answer Judge Quattlebaum's question to your opponent. What do you say the standard is for us to review that waiver here?
I think under Robinson, it's de novo. I think that's in our brief at page 10 of our brief.
Mm-hmm.
I'm fairly certain that that's the case.
All right.
Although technically the judge didn't, I guess, rule on the issue, although certainly indicated that she was going to find that the waiver, if she did
Well, if
get
it's
to
de novo, I don't suppose it matters, does it? It's a de novo, and we look
Right.
at the totality of the circumstances.
Sure.
Okay.
Yes, sir. So, in this instance, when you look at what was waived, if you look at pages 187 through 190 of the joint appendix, you actually see that it's more of a causation argument. It's not the charging in the indictment of death results language, particularly at page 188 of the sentencing transcript. There's a whole discussion about what the pathologist was going to be able to testify to, and it was clear that the pathologist would be able to say that the victim died of the cocaine and heroin that Mr. Young sold to her, but would not be able to say categorically that the crack alone would have caused it, although it would have been arguably a contributing factor. So I don't want to belabor that. Y'all can see the language, but it's clear that there was a causation argument at page 188 of the joint appendix that was waived by Mr. Young.
Well, when you see a very experienced judge like this who makes a decision, it's not a waiver, and then you read what's going on here, there's a lot of back and forth going on here, and I understand there may even been some attorney strategy in terms of what's going on, this causation thing. I mean, it's not clear as to what did cause this lady's death and the whole bit, and it really gives us pause even in a de novo when I see Judge Curry do that in a case of this nature. So, I don't know if we read in between that or what, but it feels a little uneasy now to come back and second guess him on this, with all that's going on,
Yes, sir.
Even though we can, I understand we can.
I'll reveal the fact that both Ms. Harrell and I clerked for Judge Curry, so we are very familiar with her carefulness. Yes. So, well,
I guess you didn't have a conflict of interest since both of you clerked for him. Then that's pretty good. So go ahead.
So, Mr. Daly, and this, if it may be, maybe this doesn't matter as much if, depending on how we do the 2241, maybe it does. But I mean, I guess if you lose under 2241, I don't really understand why you need the waiver. But nevertheless, let me ask one more question about the waiver issue. It looked to me like on 188, the phrase would not apply, was the provision or the language that might best, support Judge Curry's, interpretation of the waiver. And I don't know if you have a response to that, but I have a little of the same feelings Judge Wynn has. I kind of read this and thought it was, more of a causation, to be frank, black, just on paper. But given her finding, I was looking to see what would do that, and I wonder about that would not apply language. What's your response to that?
I'm sorry, you're at page 188?
Third line on JA 188. It's right where you were talking about the discussion in the sentencing hearing.
Yeah, so that language, if you look at it, it is then followed up by a whole discussion about the causation issue, and it's talking about the sentencing guideline, and there's nowhere where there's a discussion that the death results language needs to be included in an indictment.
Okay. Do you think we can look at the plea transcript on this issue? Is that relevant for consideration?
In all candor, I think that it would not be appropriate for you to read only the sentencing transcript. I think it cannot be read in isolation. In your de novo review, you should look at both the plea transcript and the sentencing transcript, because I think that's the only way to get a whole picture. So, for those reasons, I think the waiver should apply. But more importantly, I think you should, in the first instance, do what the district court judge did and say the settled law of this circuit and the Fourth Circuit didn't in any way state that barrage applied to any sentencing guidelines, let alone this one, and therefore should not apply. And then so she was correct in finding the second prong was not met for the Wheeler test. And so for those reasons, we would request that you would affirm the district court's dismissal of the 2241 petition for lack of jurisdiction.
Thank you, Mr. Daly. Judges, do you have any further questions? All right, all's clear on that front. Ms. Harrell, do you have some parting remarks in your rebuttal? You may proceed.
Thank you, Your Honor. To Judge Harris's question about whether one can waive a fundamental defect under the fourth prong, I think it's pretty evident in the Braswell case that this court decided that, waivers are not enforced if they result in a miscarriage of justice or an illegal sentence involving fundamental issues. And I would certainly agree with Judge Harris that you would not be able to waive a fundamental issue, a fundamental defect, and that the Braswell finding that Mr. Braswell had not waived his claim would also apply. I don't disagree with Mr. Daly about the de novo review of a waiver. I simply had not prepared that particular question. And it obviously would make a tremendous difference in the calculation of Mr. Young's sentence, that the guidelines be correctly calculated at the time of his offense. At the time of his conviction, the statutory sentence was 10 years to life, and the guideline range was calculated to be under that 120 months, which would have been the mandatory minimum. So that would have raised his guideline sentence to 120 months. It's only because of the application of this Burrage type language, this death results language, that his guideline range rose dramatically to 360 to life. So that if it were recalculated today under the current statutory language, statutory penalty, it would be significantly lower. And of course, the district court could then recalculate his sentence if this, if the Burrage language was taken out. I had one more thing to say, and the train just went completely off the tracks. That's all I had, Your Honors, unless you had any other questions.
Okay, I almost gave you a pun and said that off the tracks was the case we just heard before. But,
that's true.
Well, thank you both for your arguments today, and thank you for this unique format. I think it's working. Judges have asked all the questions they need to ask, and we fairly understand the case before us, and you will hear from us in due course. So stay safe, and until you have an opportunity to be with us again.
Thank you very much.
I'll ask the clerk, if the clerk there to adjourn the court for today. Perhaps the clerk is not with us, but I'm with us. Okay, this court is adjourned until we resume